All right, good morning, good afternoon, or good evening, whichever it happens to be. Welcome to Chapter 8, which will put us smack dab in the middle of our course here on the Introduction to Criminal Justice, and we're continuing our transfer over to talking about the court systems, using the transition model of addressing constitutional rights and constitutional issues, flowing between the last chapter, which focus some on the police and the Constitution, and this will focus some on the courts more, quest for justice. And that's an interesting term, I think, that we'll have a little bit of time to talk about. So a few questions to ask. First of all, the reality versus the image. One of the themes I've emphasized in this course is the difference between the perceptions people have of what's happening, what's going on, what they expect out of systems, and the reality of it. So I think as much, if not more, than the police, there is a popular image of the courts. So they're a frequent vehicle in drama and in comedy. I think because there's an inevitable conflict, you've got two sides. And I think, much like people enjoy watching sports or teams or even individuals in, say, a tennis match or football teams, much as though they enjoy that, I think the drama of a prosecution versus a defense lends itself to that. And I think that's fine. I mean, we function as a myth culture. But you have to ask yourself, are the depictions that you're seeing realistic? I think one of the first questions would be, is it really that common to have trials? The next thing to think about is, since we're going to be talking about the courts, is who are the individual actors in them? Now, they're each going to have their roles, but where do they come from? What parts of society? What parts of the economic classes, social classes, political classes? What about their, you pick whatever, because they have an effect. Race, religion, ethnicity, all of those, I think, could have an impact. So does the impact of who's sitting on the court change how the courts function? And of course, one of the last things to talk about, and this is somewhat contentious, but I think it has to be examined, is what role does politics play with the courts? Do they have a conflict, or are they a guiding principle of shaping what's going on with the courts? Okay, so your book gives 4 quick possible functions of the court, and like many things, when we start off, when someone gives you a list and says the reasons for this are A, B, C, D, I think it's fair to ask, why did you select these 4? Are they the only 4? Are they the most important 4? But we're going to look at these 4 because I think it's a fair overview. I think there's a few more things courts do, but this is a fair overview of some of the major functions. Due process. The courts are, in theory, the guardians of the individual rights of the Constitution. If the police are interested in crime control, remember that mechanism, that conflict between crime control and due process, then the courts should be interested in due process. All right, well, crime control, because even if the courts are interested in due process, they have a function in maintaining order in our society, both order in the social sense, the economic sense, the political sense. Rehabilitation. Particularly in America, with such high numbers of people coming in contact with the legal system and potentially going to prison, jail, being placed on probation, rehabilitation has to be of major concern to the court. What crimes are people rehabilitated for, or could be rehabilitated for, and how effective are we? Bureaucratic. Like any organization, it doesn't exist in the abstract. It exists in the practical. They have resources. There are only so many judges. There are only so many hours in a day in which cases can be heard. How do they process the paperwork? How do they proceed in just a simple technical sense? Now, one of the things that your book doesn't direct immediately in its language is it throws about the term jurisdiction But I also like to throw about the term venue, so you don't get confused when a lawyer's talking to you or someone's talking about the system, and they say jurisdiction. That is the authority of the court system, which is spelled wrong there, but I'll correct that. That's the authority of the court system to hear a case. The venue is the proper court inside that system. So quickly it would work like this. If you killed someone in Wake County in Raleigh, the North Carolina criminal courts would have jurisdiction. The proper court inside the North Carolina court systems would be the Superior Court, because they hear most of the important felonies, and the Superior Court that sits in Wake County, so we would say Superior Court, County of Wake. They would have venue. Okay, typically when we talk about criminal jurisdiction, it's really based on geography. We simply ask where the crime occurs. Whatever, there are 50 states, 46 states, and 4 commonwealths if you like, and then you've got Puerto Rico, Guam, and our associate territories. But realistically, let's stick with the 50 states. When a crime occurs, we'll say, okay, this crime occurred in Montana, this crime occurred in Florida, this crime occurred in New York or North Carolina. That would mean that those states' courts have jurisdiction. And in 99.9% of the case, that's going to work. Now, in some instances, it's not as important where the crime occurred, but what kind of crime it was. There's a limited number of crimes. Treason might be one at a federal level. Bankruptcy, fraud, for example, is important, where it occurred, but subject matter, what it is, can be more important. For example, bankruptcy is pretty much strictly a federal subject matter. There are no state bankruptcy courts. You don't go to the state of North Carolina and say, I want to declare bankruptcy. You have to go to the U.S. Federal Bankruptcy Court. Okay, trial courts and appellate courts. The trial courts are what we call courts of original jurisdiction. And a trial court where the trial court judge really wears 2 hats. He hears evidence to establish what the facts are. Did John shoot Mary? Did Mary rob the bank? Okay, so he hears that evidence. But he also deals with some issues of law. The police have a video. Should it be admitted? The forensics tests on the bullets came back. Should they be admitted? So he does hear facts. And that's more what a trial court or a court of original jurisdiction does. Now, the big difference, and this is something that really, boy, I think most people don't understand, is the appellate courts are not concerned with facts. So the appellate courts are not, except in some rare instances, concerned with what time the bank robbery occurred. What they're concerned with is, was there an error of law at the lower court level? Now, the error of law at the lower court level might impact a fact, but an appellate court simply says, here's what the law said about the admission of ballistic evidence. Here's what the law said about admission of video evidence. Not the specific one you're talking about, but we're going to apply it to that. So it says videotapes only get in if you can show a chain of custody. You couldn't show a chain of custody. Therefore, that videotape should not have been admitted. An appellate court writes their explanation, and that explanation is called an opinion. When you are reading a court case, when you say, well, I'm going to read Plessy versus Ferguson, I'm going to read McCulloch v. Maryland. When you go back and you read those cases, you are reading an appellate case. You are not reading a trial court case. All right, we have a dual court system. We have the state courts, which do most of the criminal work, and we have the federal courts. State courts enforce state law, federal courts enforce federal law. Now, sometimes you violated both. So, for example, let's suppose the Secretary of State was in Raleigh, North Carolina, and you shot him. it would both be a crime in North Carolina, assault with a deadly weapon inflicting serious injury, and you could be charged under North Carolina law. You could also be charged under federal law. I'm assuming, I don't know if there's a specific statute, but I just about guarantee you there is. Assault on a federal official. Now, the interesting thing there is, because some students say, well, only one can try, right, Mr. Chapman? No, they actually both can, and it is not double jeopardy. It's not being placed in danger twice for committing the same crime, because they're different crimes, because there's different sovereign entities that are prosecuting you. All right, the next slide I want to show you is not in your text. This is a breakdown, a fairly recent one. The numbers are going to be a little bit different, not much, of the North Carolina court system. Now, you notice at the top of the North Carolina court system we have the North Carolina Supreme Court, and there are 7 justices on the North Carolina Supreme Court. Just below that we have 15 judges that sit on the North Carolina Court of Appeals. Then we have the Superior Court, so it's 109 judges. Now remember, we have 100 counties in the state of North Carolina. And that would mean that approximately every county has one Superior Court judge to hear the felonies that occur in it. Now, if you're talking a small county like Northampton or Maynard up in the mountains, that would probably be more than enough, because you might only have 15 or 20,000 people living in the whole county. But if you're talking a county like Wake or Mecklenburg or New Hanover down on the coast where Wilmington is, or over in Durham, you might have 1 million people living in those counties. So one judge for 1 million people is not enough. So when we say there's 100 counties and 109 Superior Court judges, remember that there's often more Superior Court judges in a given area and fewer in where there's less population. The same is true of district courts. They don't just sit based on county. They sit based on a judicial district. So there's 256 district court judges, and they're going to hear most of the paperwork, most of the administrative work that comes through, with exception of some of the pleas, like pleading to a quick traffic ticket. And that's really going to be done in magistrates. And we also let clerks handle all that too. So you've got your trial court administrator, your clerk's Superior Court, and then you've got the administrative office of the court. So it's a relatively, for a state that over time can have 5-10 million people in it, it's a relatively small number of people that work in the system, which is really your first hint, of course, I would say, that there are not going to be as many trials as you think. All right, so North Carolina does have magistrates, and these magistrates exist in most states in different names. They might be called a justice of the peace in one place, they might be called a magistrate in another, and they're going to handle very minor matters. They might do things like, on a simple arrest, set bail. They might issue simple arrest and search warrants. They might handle initial appearance, where you are brought in and there's a determination of probable cause. Magistrates in North Carolina are appointed by the senior Superior Court judge, and they serve a 2-year term, and then there's a 4-year term they serve, just to make sure that they're doing a good job. And they're slowly been professionalized. When I first started practicing 30 plus years ago, magistrates didn't even have to have high school educations. And you can see that since you've got someone who's elected, the senior Superior Court judge is elected, and he's going to be able to appoint someone to a job, that's a political appointment. There's no way around that. All right, our trial courts, we have 2. The district court, as I said, handles most minor criminal cases. There's no juries there. And in fact, since most criminal cases are minor, they're going to handle most criminal cases, period. Their workload is probably 4 or 5 times what the workload of a Superior Court judge is. Your Superior Courts handle most of the felonies. Now, we also have 2 appellate courts. We have the North Carolina Court of Appeals and the North Carolina Supreme Court. All North Carolina judges are elected from district court on. So the district court, they're going to run, the Superior Courts are going to run, Court of Appeals are going to run, Supreme Court's going to run. And their terms are a little staggered. They might be 4 years, they might be 6 years, they might be a little bit longer. But you're going to see a name on the ballot. Now, there's always been a lot of fight. Should they they be elected? Some people say, well, what does the general public know about judges? How are they qualified to select a judge? I think that's a fair criticism. And I think you can ask the question, if you've ever voted for a judge, and if you voted in North Carolina, you've probably voted for judges. Did you know them? Do you think they were qualified? And, conversely, I think it's also fair to say, well, you voted for someone for the North Carolina State Senate and the North Carolina State House. Were they qualified? Did you know them? Why are you singling out judges claiming they have? I would argue they do, but why are you singling out judges and say they have a unique skill? The federal court system is a little different. The federal court system, and we're going to look at a map of this in not too long. The federal court system, there's only one basic trial court. And I'll bring up a diagram of this in just a second, but there's only one basic trial court. It's called the U.S. District Court. There are two Court of Appeals. There's what's called the U.S. Circuit Court of Appeals, and then the biggest, the big dog, and the most important, the United States Supreme Court. All federal judges are appointed by the President and confirmed by the Senate. Now, it's a two-part process. The President has to select you. So right now, President Biden would say, okay, I want John Smith to be the federal district court judge for the Eastern District of North Carolina. I'm going to appoint him. And the Senate would have to vote. Now, if the Senate's in the same party as the President, likely that they're going to vote for him. But, we've seen historically in the past, the President says, okay, I want to appoint this guy even to the Supreme Court. And the Senate says, well, we're going to count on you not winning the next election, so we're not going to even have hearings. It's not that we're going to say that the guy you appointed is no good. We're just not going to confirm him. So the system's a little bit broken there, I would say. All right. These next two charts, this is the jurisdiction of the U.S. federal court system. And you can see that you've got the Court of Appeals, the different 12 circuits, and we'll look at those in a minute. We've got the tax courts. We've got territorial courts. The big one here, and I'm not quite sure if you can see that, is the district courts where they come out of. Here's a geographical breakdown, and you'll notice that we're in the Fourth Circuit Court. So we're in there with South Carolina, Virginia, West Virginia, Maryland. We're a medium important circuit court. There's some important decisions that come out of us. If you're looking at, say, death penalty cases, since the states that do most of the execution are Texas, Florida, and Oklahoma, you would have to look to definitely the Texas cases, number 5, Fifth Circuit, a little bit Florida, 11, a little bit Oklahoma, 10, because Oklahoma really has a high number of executions. If you're looking at important financial decisions like financial fraud or stuff like that, well, the financial capital in the United States is New York City, so you would look at the Second Circuit. And a lot of cultural decisions, unsurprisingly, come out of California, so that's the Ninth Circuit. And there are some circuits that aren't that important. And it's not to say the people in them aren't important, or there's an important law that sometimes comes out of it. But if you look at, say, the Eighth Circuit, which has got North and South Dakota, Nebraska, Minnesota, Iowa, Missouri, and Arkansas, there's not a heck of a lot of important industrial, economic, or cultural centers there where a lot of groundbreaking law is going to come out. Okay. Again, I want to emphasize that courts of appeals do not concern themselves if someone is innocent. You do not appeal from a conviction at a trial court saying, I didn't do it. You appeal saying that the trial court made an error of law. They admitted a testimony that shouldn't have gotten in because it was hearsay. They admitted ballistic evidence that shouldn't have got in because it didn't meet scientific standards. To appeal a decision, you have to show this error of law. Now, that might mean, hey, this error is so serious, it led to an innocent person being convicted. But that's a secondary result. As of 2016, only about 10% of criminal appeals are successful. And that should tell you that the the trial courts, when there are trials, okay, they're right about 90% of the time, which is a pretty good rate. Not fantastic, but pretty good rate. All right, let's talk about the biggest of the big dogs, the United States Supreme Court. Now, there's a few things about the United States Supreme Court. First of all, we're very used, and this is chronocentric and ethnic-centric again, to the current structure of the federal Supreme Court. 9 justices. There have been more justices, there have been fewer, but it's been stable for going on 100 years. We call 8 of them the associate justices and the head of the court the chief justice. The court has the power to shape the law because they exercise something called, and we're going to talk about this in the next section, judicial review, the authority to declare a law unconstitutional. They interpret what a law means. Now, in fact, the Supreme Court of the United States, for all its power and all its majesty, there's about 7,000 cases that are appealed to the United States Supreme Court in a given year. They only hear about 100 to 150 cases. So that's, yeah, I know it's a little imprecise. That'd be about 1 case every 3 days. And remember, they're not having a trial. They're just having briefs written for them and evidence, more on that in a minute, is not being presented. They're really just hearing what lawyers have to say occurred at the lower trials. And it doesn't get to them unless at least 4 of the judges, this is called the rule of 4, say, yeah, this case should be considered. All right, now I said I was going to talk about the judicial review. Judicial review is something that the United States has kind of struggled over. Now I'm going to use somewhat loaded terms. I'm going to talk about liberal and conservative. It doesn't necessarily mean exactly what those terms mean in the political sense. The 2 basic positions, as people understand the interpretation, is there are liberal judges, sometimes called living constitutionalist judges, that say you just can't rely upon what is written. There's more to the law than what is simply being reduced to written statute. So if there's a statute that says this occurred or that occurred or this should be done, you have to apply that statute, but you can also bring in external factors to consider it. Now, the conservative approach, which is more accurately called the strict constructionalist approach, and this is, I would say, the dominant approach of American conservatives in the political sense right now, says, oh, no, no, no. The Supreme Court, all courts, in fact, should look what the law is being written. And so long as it's not a clear violation of the Constitution, it should apply the law as written, period. Don't bring in other things. If it's not on the page, you can't mess with it. It's up to Congress. Okay, so those are the 2 extreme positions of judicial review, and of course most judges are going to fall between those 2. Now, from a personal opinion, I think the strict constructionalists have a big problem, and the big problem is the whole idea of judicial review. Remember, judicial review is the power of the Supreme Court to gather in information and declare a law unconstitutional. A Superior Court judge, which is going to say, a Supreme Court judge is going to say, okay, using strict interpretation, I'm going to declare this law unconstitutional. They really can't. And the reason they really can't is that in the most little or most extreme, you'd have to find in the Constitution where it says the Supreme Court of the United States has the power to declare a law unconstitutional. Remember, strict constructionalists say, look at the document. You know, sometimes they're called textualists, sometimes they're called literalists, but look at the document. If it's not there, you can't use it. Well, guess what? There's nothing in the U.S. Constitution that says the Supreme Court of the United States can declare a law unconstitutional. That is an assumed power. It very much derives from and again, these terms are not the same as the 20th century term. These terms are that's very much a liberal idea, that you can declare a law unconstitutional. Now, the courts clearly today exercise judicial review. Sometimes they do, sometimes they don't, but they clearly say they have that power. If a law is unconstitutional, it is seen as violating part of the U.S. or state constitutions and is struck down. It rarely happens, although it's more common today than it's been in the past. I mean, until the 1860s, you only had a handful of cases where the Supreme Court of the United States, like say McCulloch v. Maryland, started to strike down laws and say they're unconstitutional. There was kind of an explosion of the court, in a relative sense, still not a lot of cases, saying that laws are unconstitutional as the 20th century progresses. So judicial review, kind of an American concept, it says that if a law violates the U.S. or the state constitution, it can be struck down. Now, the Supreme Court and most appellate courts do not hear evidence. Instead, what happens is each side that's arguing. So right now we're having a controversy over the fetal heartbeat abortion law in Texas. Now, this might be solved by the time you hear this, but quickly what happened was Texas passed a law that said 6 weeks after conception, essentially, if there is a heartbeat, you can't have an abortion. Well, it's going to get appealed to the Supreme Court. It's already gone to the Supreme Court once, and they kind of let the law stand temporarily. There hasn't been a full analysis of this, but they've let it stand so far. So, some people are saying, well, how soon is this? How late is this? Is this a real heartbeat? Do women know they're pregnant? There's all these factual questions. Well, guess what? The Supreme Court of the United States, if it hears an appeal on this, they're not going to call doctors in and say, okay, tell me about, fetal heart rates. Instead, what's going to happen is the two sides, and one side would be Texas since it passed the law, and the other side would be whoever sued Texas to try to overturn it. We'll just call them Smith, Texas v. Smith. The attorneys for Texas would write a legal argument, and it's called a brief. Then they would appear, and they would be able to answer questions if the Supreme Court had them, or they can give a quick little speech. The Smiths, the people that are trying to overturn the law, they would write a brief. The Supreme Court would each read the briefs, and then they would write an opinion. If the Chief Justice is in the majority, Chief Justice of the Supreme Court right now is Thomas. If Thomas is in the majority, then he gets to write the opinion or decide who writes it. Okay. If judges don't agree, so I would imagine Sotomayor would be a dissenting vote here, she might write what's called a dissent. Now, you might have people that agree, that say, oh yeah, I like this, say Alito or someone like that, or if we went back, Scalia. Scalia might write an opinion and said, I agree, but I don't agree for the same reasons that Chief Justice Thomas agrees for. All right, the judge. Let's talk a little bit about the judge. The judge wears different hats. He's not separate completely from the courtroom. Remember, this is an attorney. It's an attorney that is going to be selected or elected. So he's got one foot in the political realm to some extent. Before trial, judges often play negotiators. They will apply pressure to both sides to settle cases. Because remember, if there's only 250 Superior Court judges in North Carolina, and there are hundreds and hundreds of felony cases, there's no way they can have all these cases go to trial. So one of the things that judges will do is they'll say, all right, let's see if there's a settlement here. Can everybody agree to this? Can everybody agree to, plead to a lesser felony? Once the trial starts, that type of pressure should disappear. They should be more neutral. They're more referee between the two sides, and they're really responsible for ensuring that the law is followed and applied. He also, if there's a jury, which you got 12 people sitting on a jury, if it's the classic jury, and they don't know the law, they might have questions about the law, the judge instructs them, tells them, this is what we mean by this, here are your instructions. He's also got administrative function. He's got to keep the docket moving. He's responsible for the day-to-day function of his courtroom. All right, so a little bit quickly, a little bit back. The judge makes rulings if the trial should continue. Most lawyers will win or lose their cases before the trial starts. You might file a motion in front of a judge and say, hey, there was no probable cause for this arrest. Judge looks at it and says, hey, you're right, there's no probable cause, case dismissed. Or, oh, you're completely wrong, there was probable cause, we're going to go forward. So the judge will do these things. He'll make rulings. Very critically, they usually will approve of plea bargainings. Now, realistically, if we look at, say, a district court judge, he's going to have hundreds of cases scheduled on any given day. It would not be unusual for a sitting district court judge in Wake County to have 200 cases assigned to him on a given day. Now, a lot of these are minor. They might be a misdemeanor. They might be a traffic. They might be a speeding ticket. But even if, let's just suppose he had 200 speeding tickets. All right, so if you're going to have a trial for each one, you got to swear the defendant in because he's going to testify. You're going to swear the police officer in because he's going to testify. You've got to have the police officer tell the story why he stopped him. You've got to have the police officer admit evidence like, here's his driver's license, here's the speed of the radar that I got. Now, wait a minute. You might have a challenge. You might say, well, I want to admit the records for, is the radar gun calibrated? I want to admit the scientific basis of whether the radar is accurate or not. So you can see how even a simple speeding case might take 10 minutes at a minimum, or more likely, say, half an hour. Well, if a speeding case, and there's 200 cases, takes half an hour, and you've got 8 hours in a courtroom day, that means that you can hear 16 cases. If you could do it in 10 minutes, which would be flying through it, okay, you're still looking at 6 cases an hour, 6 times 8, it's 48 cases a day. And that's doing nothing but speeding ticket cases, bam, 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 bam. At trial, they're supposed to be neutral. They rule on whether evidence gets in and whether witnesses testify. They also control the courtroom. The judge has the power under contempt to do almost anything. If the judge thinks that someone's being disrespectful, if the judge thinks someone is acting violent, or if the judge, he has the power essentially to send them to jail for brief periods of time. It's the power of contempt. He is going to, and some judges really run their courtrooms with an iron fist. Some do it by projection of personality. Some do it by consensus. But he's in charge at the end of the day. After trial, of course, if someone's acquitted, if they're found not guilty, he's going to get released. But if they're guilty, there's sentencing guidelines, but the judge at least has some power in sentencing. Now, we've taken a lot of the almost unlimited power judges used to have away from them, and we've gone towards structured sentencing, but more about that when we get to it. Okay, how do we get judges? And I've danced around this a little bit before. As I said, all federal judges appointed by the president, confirmed by the Senate, if they can agree. State judges of a small number of states kind of use the same system, just the governor appoints. But in most states, in some way, shape, or form, there's either election or merit selection. Now, election, which is what most states do, you either run in a regular election, you got a little D next to your name or a little R next to your name. Some states say, no, we won't make this. We're not going to identify people by political party. So it can be a partisan or nonpartisan. Sometimes what happens is you get what has been called the Missouri selection system, where you get a judge appointed, he serves for a time, then he's confirmed or not confirmed. So it's kind of a mix between the two. Judges are typically subject to judicial oversight for misconduct. You can vote a judge out of office, of course. You can remove him for judicial misconduct. That's pretty rare. I think I've seen here in Wake County one really serious case of judicial misconduct where a judge was off the bench. A lot of times when it gets bad, they'll remove themselves. They'll resign, but they can, in theory, be removed. They can be impeached federally. So if you've got a judge, and this is exceedingly rare at the federal level, and at the Supreme Court level, it just doesn't happen. It could, but it doesn't happen. All of these are pretty rare. Most of the time, if a judge gets in, he's in. Diversity. We'll talk a little bit about diversity on the bench. If you walk into any American courtroom, you're going to notice a few things. One, when you look at the judges, particularly at the appellate level, they're white and they're men. Now, there's nothing wrong with that. I'm a white man myself. But there is a notable absence of alternatives. So there's not as many women. There's not as many minorities that sit on the courts. Well, okay, is this important? And you know, your book focuses on these two things, but you know, there's other things you could ask, like should there be diversity of religion? How many? Let's take the Supreme Court of the United States. There's a lot of Catholics on the United States Supreme Court compared to the general population. Statistically, far more. Should religious diversity be brought in? What about age diversity? If you're having a bunch of people in their 60s and 70s make all these decisions, you might say, well, they're wise. Well, yeah, they're wise. But young people bring something as well, if you're talking about diversity. A 20-year-old, for example, or a 30-year-old might know a lot more about technology than a 60 or 70-year-old judge. What about gender? What about ethnics? What about economic class? If you've got people that have never been hungry and they're sitting on a bench, that's going to create something different. So there are benefits to judicial diversity, although where you choose to put that diversity, I think, is a debate for society. People do tend to trust judges that resemble themselves more than others. And you can enrich a judiciary by introducing a variety of voices and perspectives into positions of power. So says your book. All right, the courtroom group itself, each unit, each part of this unit, that's the judge, the prosecutor, the defense attorney, those are the big three members. You know, they have far more in common with each other than they do with their clients. So the judge, the prosecutor, and I, we all went to law school. We all probably know each other. And if you're in a small county, for a while I practiced law way up in Mitchell County, North Carolina, which is up in the mountains. You knew the judge. When the courtroom broke, you went to the diner. There was only one diner when at Bakersfield, I think, it's a lot of years ago. There was only one diner there to eat at. So the judge, the DA, and I, because there were only 4 private attorneys in the county, we all went down to the diner and ate together. So there's this interaction. I mean, we knew each other. Then there were other people. There's other people in a courtroom. If you go into a courtroom here in Wake County, you'll see that the sheriff of Wake County has assigned a bailiff, an armed deputy who's in each court to help maintain order physically. Then you got your clerk of court who's going to process all the paperwork, which is very important. And then you got your court reporters who are going to keep a record of it. So you've got all these participants, and it's a cooperative unit. It's not a combative unit as much as you might think. Having said that, let's talk about the combative unit, the adversarial system. At the core of the American system is this idea that if the prosecution and the defense fight each other in court, contend, vie against each other, that this competition produces truth. And, you know, that's an assumption. It's an assumption that is so common that we don't even question it. But I do think that when you go to college, it's time to question fundamentals. Now you might say, well, there's no real alternative to this. That's great. I think there are alternatives. I don't think the alternative is necessarily better or anything like that. But you need to ask yourself, does it work? Does having a neutral judge or jury to decide the facts, having each side present their evidence, through a series of structured procedures, and this competition produced a truth. And I think there's some things that are underlying that. First of all, that is the judge really neutral? What evidence are you letting in to be presented? What are the resources of each side? If you've got the New York Yankees playing against the Podunk Little League team, let's call them Paducah. The Paducah, Illinois Little League team might be the best Little League team around. But the New York Yankees are going to destroy them because they've got the resources. So not all competitions are fair. If the competition needs to be fair in some sense, then you have to ask the question is our adversarial system creating a fair adversarial system? Does it really work? Isn't this really to some extent, and this is, again, if we had a lot of time, we could talk about this. I'm a bit of an amateur historian, and I can remember when I first started studying, this is 4 decades or so ago, reading about trial by combat. The idea that God would protect the right, that if you have two people fighting each other in a physical combat in the medieval world, that God would protect the righteous side. Whoever wins is protected by God, who must be telling the truth. Well, that seems kind of silly to our modern ears. Although, I think you make a religious argument for it. But is it that much different than the idea that the adversarial system produces the truth? Does the adversarial system really emphasize discovery of truth, or is it really centered on victory? And those are two different ideas. What alternatives exist? Remember, I said this might, because I don't want to be too critical here. This might be a flawed system. There might be the problems. Okay, great. It's got this, and this flaws. You got another system that's got a better alternative. So, for example, the Europeans tend to use what's called an inquisitorial, where you've got a judge who's got a lot more power asking questions, than an adversarial, where the judge is neutral and the two parties strive against each other. Okay. Kept this one relatively short because the last one went a little bit over. Other than that, you all have a good day, good afternoon, or good evening, and I will see you for Chapter 9 when you're ready.